Thanks very much for the invitation, dear Lionel, dear Christina, dear David. Although it was a challenge when you invited me, Christina, and told me that I should take a blue sky approach when coming here to Cambridge, which actually reminded me of a famous quotation in Germany of our revered Federal German Chancellor Helmut Schmidt, who once said, "When I have visions, I immediately go to the doctor." And as a German lawyer, I also feel a little bit like that, closer in my approach to Bob the Builder than to Sir Norman Foster, although I admire that building here since I came here first in 98. And so I was somewhat left in a quagmire. On the one hand, feeling like a German lawyer who'd rather act in the role of a plumber, let's say, try to bring you some news from Brussels, inter alia, about the current status of discussions in the Council Working Group. And then on the other hand, of course, I wanted to fulfill the task which was assigned to me and concentrate on an outlook, a way out of the dilemma in 2 stages, which my colleague Axel Metzger from Berlin and I have proposed in Germany. And so while the first 3 points have been worked through in the event today, I will concentrate on 4 and 5 and report on the current situation in Brussels, actually as it was negotiated on Thursday, on March 8, in the Council Working Group, and then perhaps discuss a little bit our idea or a model, which of course also is rather a thought experiment than a realistic political proposal, but so far I feel justified because of the blue sky. We've talked a lot today about the original approach of the Commission in the Digital Single Market Directive, combining standalone duties of care with an attempt to clarify the CTTP right in the recitals to the directive, very strange regulatory technique, as well as an attempt to restate the court's case law on the provider safe harbors. Very justifiably, there was a lot of discussion and controversial discussion on this in the aftermath of the original proposal. The member states asked questions to the Council Legal Service on the compliance of that recital 38 with the communication to the public right, and in particular the court's case law on Article 3 of the InfoSoc Directive, the compliance of the proactive filtering duties with fundamental rights, as well as with Article 14 and 15 e-commerce directive, of course, was very controversially discussed. And actually, as for the communication to the public right, well, that whole development was going on. From my personal point of view, secretly, the CGEU was effectively overtaking the approach of the Commission, construing Article 3 of the InfoSoc Directive, the communication to the public right, effectively in a way to include a lot of more distant, indirect contributory liability cases into the very concept of infringement, instead of dealing with them under the heading of accessory liability. In German case law, this wouldn't have been possible because we have a rather strict requirement of specific knowledge as a condition of infringing the CTTP right. So when we had the very widely noticed court's case of GEMA and YouTube in both the Hamburg and the Munich court, both courts decided that YouTube wasn't an infringer, even although it was a very active provider, very much structuring the content, very actively structuring it. Still, they decided there was no specific knowledge, therefore only the infamous concept of a German Störerhaftung would apply, leading to injunctions, but not to damages, and leading to very extensive filtering duties, actually filtering duties which were so costly that recently the case was settled between GEMA and YouTube, and in the end of the day, YouTube is licensed under German law, although that is a secret settlement, not really a good solution, in particular when you want to treat other platforms equally under these conditions if you don't even know how they've settled. Not a good situation for smaller platforms, and so forth. In other countries also, actual knowledge was required, either for infringement or for getting out of the safe harbors of the e-commerce directive. There's a lot of comparative law research in Christina's dissertation on that. However, in the ECJ's case law, also already very early in the Airfield and Canal Digital case, there were certain notions of concentrating Well, on the role of the user, the role of the intermediary, and the question of whether he made consciously available the material accessible for a respective public in the framework of an own structured service, so of whether he was using the work as a work, in a structured way, structuring the contents with a specific relation to the work and the content of the work as such. And this, since then, has developed into a flexible system of typological elements to identify economically relevant use from my point of view. So, for example, certain merely technical rebroadcasting services would be out. First-time IPTV would be in, like in the ITV case, and these structured services would be in as well. And now this has been complemented with a very recent line of case law, which we haven't discussed extensively today. And these are, of course, the GS Media, the Filmspieler, and the Pirate Bay cases. And in these cases, what the court has effectively done is the court has construed a concept of secondary infringement in the realm of a test for direct infringement under Article 3 of the InfoSoc Directive. This first concerned private and commercial link posters. It is by no means self-evident that a link poster actually acts within the realm of an act of communication to the public as an infringer. However, the court didn't even consider to apply accessory liability, probably because that isn't harmonized in the first place, and of course they wanted to widen the realm of harmonized law. But instead tried to construe a concept of secondary infringement within the very realm of Article 3 InfoSoc Directive. And actually what they did made sense to a certain extent, in particular with regards to private link posters, which effectively would be under a duty of care, which amounts to a notice and takedown duty, and communication to the public would be triggered if private link posters wouldn't comply with this. With regards to commercial link posters, and that is a very wide notion, as we have learned from the Pirate Bay, that would be any link poster who is refinancing his homepage by relying on advertising revenues, which essentially would be almost every internet website. So for those commercial link posters, the essential criterion of knowledge about the illegal material being posted by the link would be presumed, although the presumption would be rebuttable, on the condition that the link poster showed that he complied with reasonably and proportionate duties to check the source of the content, the legal status of the content, and so forth. Actually, the court was a lot criticized for that presumption because quite obviously that presumption is realistic. We've discussed that a lot in individual link posters, such as that Dutch Geen Steel media site, which was individually posting links of a very dubious content, actually, of course might check some of these links with regards to the legal status of the sources. However, large aggregators, such as in search engine, for example, or even the Pirate Bay, of course couldn't make these checks on the basis of a mass aggregated service. So the presumption as such isn't really realistic, as Advocate General Spooner pointed out in the Pirate Bay case. It fits for individual links, and it fits for those commercial platforms which don't react to notices, but it doesn't fit for a large aggregator. The court didn't follow this in the Pirate Bay because for the court, general knowledge of the infringements on the Pirate Bay was enough anyway. They didn't ask for specific actual knowledge, at least not with regards to such a heavily infringing platform. However, there has been a different approach in a very recent case decided by the German Federal Court of Justice. And the German Federal Court of Justice, in September 2017, and the reasons have been published beginning of this year, had to render a judgment, the third judgment of the BGH, on Google's image search. And actually, the Federal Court of Justice in Germany clearly said that the presumption of knowledge from GS Media wouldn't apply to a search engine or even the image search function of a search engine, as this would be a large aggregator where the balancing of the involved fundamental rights would lead to a different result. Instead, the link poster to the results of Google's image search, or Google's image search itself by implication, would only be liable as a tortfeasor on the condition of the violation of reasonable and proportionate duties of care. So again, a duty of care-based concept. That is a Janus-headed judgment, because on the one hand, the Federal Court of Justice accepts the leveling of the differentiations between the headings of tort, direct infringement, and accessory liability. They could have argued that Google's image search only gives grounds to an action under accessory liability. Instead, they said, no, this might indeed be a direct infringement, insofar following the ratio of the GS Media case. But on the other hand, they said the presumption doesn't apply. Instead, we have to ask of whether the infringer violated reasonable and proportionate duties of care, or whether that limitation of the knowledge presumption from GS Media is really compliant with the ECJ's case law is an open question. The German Federal Court of Justice said this is just application of the law. This is within the boundaries of applying the European tests. From my personal point of view, the judgment shows that the ECJ's case law indeed opens an avenue for reasonable and proportionate solutions. And that is when you read GS Media carefully, what they say is a commercial link poster will be presumed to have knowledge of the illegal character of the linked content because it can be expected from a commercial link poster to comply with certain duties to check that content which are reasonable and proportionate. From this follows for me that whenever the link poster complied with those reasonable and proportionate duties of care, the presumption wouldn't apply. And that would mean that in the case of a mass aggregating service, even complying with certain minimum duties of care, such as reacting to technological opt-out flags on the net, would be enough to get out of the presumption, because all the other duties the mass aggregator could comply with would be disproportionate. So there would be a way out of the dilemma, and there would be a way to apply GS Media in a proportionate and reasonable way. Of course, there's no guarantee that member states' courts will do so. The Federal Court of Justice has found a balanced solution which will work in the future for Google's image search, but we can't be certain how the presumption is applied in other member states. And certain inflationist tendencies have come up even in Germany in lower courts cases. So there is a problem here, certainly. And this problem, of course, is broadened when we look into the Filmspieler and the Pirate Bay cases. Of course, in some respects, these were examples where hard cases make bad law. Filmspieler, an infrastructure, as well as the Pirate Bay, an heavily infringing BitTorrent file information site, were both heavily infringing copyrights. And their main purpose was actually allowing users to infringe copyrights. Still, their causal contributions to the users' infringements were remarkably distant. Filmspieler concerned a purely technical infrastructure that was a set-top box used to stream online content onto your TV. And of course, there were some links on that set-top box leading to infringing sites. But whether the user actually made use of these links or not was completely left to the discretion of the user. There was no control whatsoever by the platform what the user would do with that device. Still, no doubt in the Court of Justice's view that this would constitute an act of communication to the public, although it is entirely unclear with respect to which works. But it would amount to an act of communication to the public, which indeed in these cases would amount to a violation of Article 3 of the InfoSoc Directive, since these operators had general knowledge of large-scale infringements being made with the help of their services. Now, that is a very broad concept which establishes a secondary liability approach and a accessory liability approach within the concept of infringement of the communication of the public right. And the price question, of course, is whether the court at least makes the necessary differentiation within that framework. So while the differentiation between accessory liability and primary liability is certainly leveled, the court might still make the necessary distinctions within the concept of infringement in his case law. And actually, indeed, the court might have done so when we look into the results of the cases. Because on the one hand, we have all these old cases, such as Airfield, such as ITV, and many others, where the infringer really has control, knowledge, and consciousness of the specific material involved. And in these cases of direct control, the court applies a concept of direct infringement as long as this is used in the framework of an own structured service and so forth and so forth. And then we have then more distant causal contributions where one crucial differentiation is made, and that is between neutral and those heavily infringing services. With regards to the heavily infringing services, it seems general knowledge that the service is used for infringements is enough, and this will bring them into secondary liability. With regards to neutral actors, hyperlinks, private hyperlinks, commercial hyperlinks, knowledge would be required with a rebuttable presumption of knowledge for commercial actors and resulting in a duty of care-based liability concept. So where does that leave us with regard to the content platforms? Well, indeed, from my point of view, from that case law could follow in certain specific cases that a platform which structures or optimizes the presentation of the content in the context of a service for an own receptive public, that wasn't in the directive, the proposal, thus acting close and competitive to normal exploitation, using the work as a work in the framework of a content-related service, might indeed perform an act of communication to the public. The question would then be, of course, of whether the platform needs specific knowledge, such as in the German, Spanish, Italian cases. And here the answer by the court would be, no, it doesn't need specific actual knowledge if it's a tendentious platform, such as the Pirate Bay and the like. But what about all the other structured platforms, the gray area in that regard? Well, here a presumption of knowledge for commercial platforms would apply, but that, of course, could be rebutted if the platform showed that it complied with all the reasonable duties of care, then getting out of primary infringers' liability. That might be the status of the current court's case law in the area of the communication to the public right. So indeed, Recital 38 in the original proposal wasn't way off the most recent ECJ's case law on Article 3, although, of course, it was bad regulatory technique to put it into a recital. Now, the whole thing hasn't really been improved. Meanwhile, it is in the text of the directive, and I'll come back to that shortly. But in putting it in the text, some of the qualifications even have been taken out, so it has gotten rather a little bit worse. I'll discuss this shortly, and I'll discuss it rather critically, the most recent Bulgarian compromise proposal in the Council's working group. Now, the bottom line on that very long and complicated slide is that, of course, there was a lot of discussion of whether these proactive filtering duties would be possible under the e-commerce directive. And actually, there was a lot of controversial reading of the case law as well, Google and Google France, L'Oreal and eBay and all those cases. The outcome of the Commission's legal service was that proactive filtering duties would be possible upon specific notification. That would be conceivable if there were provided specific data by the right holders and so forth. So there would have to be content-specific collaboration with the right holders, whatever that would mean. But of course, there is no doubt that the legislator could do it. And that is what the Bulgarian proposal does now. So that whole discussion becomes a little bit academic, because once putting it in the text of the directive, I think there can be no doubt that the European legislator would be able to do so. This doesn't go beyond the boundaries of the involved fundamental rights. I think that would still be an acceptable balance. So that is why that whole discussion is rather replaced with the need for political activism now, if we want to change that, in particular, when we look into the Bulgarian compromise proposal of March 2, which was discussed in the Council Working Group last Thursday, as it was mentioned by Bernd Hugenholz this morning. The Bulgarian presidency now plans to specify the communication to the public right for online content sharing service providers in the text of the directive. Originally, that definition contained some of the qualifying elements of the court's case law, but it doesn't anymore. Now the text just says, an ISP whose main purpose is to store and give the public access to a significant amount of copyright-protected subject matter, uploaded by its users, so that is a very broad definition, that is any host, is capable of communication to the public. And the only specific carve-out in the provision is for Wikipedia and some other non-profit educational or scientific material, which is, also from my personal impression in Brussels, basically because the Wikipedia lobbyists were very loud, very noisy, and have put that in a very specific way. However, there's a lot of other platforms which might have a problem here. Think of a sales platform, including a lot of photographies of the products which are sold on the sales platform. Of course, that might be copyright infringing. That is now in the recitals. So content platforms are distinguished from sales platforms, which only incidentally violate copyrights when the photos of the users are copyright protected. But the whole approach is now very piecemeal. On the one hand, it's very broad, containing any host. On the other hand, some hosts, such as Wikipedia and sales platforms, are better than others and taken out of that definition, carved out of that definition. That is pretty much a piecemeal approach reflecting political compromises instead of an overall consistent approach. But of course, the Commission and the Bulgarian presidency would answer that this whole thing is balanced by a duty of care-based infringement concept anyway. And that there is no problem in including all these hosts because they would all only commit an act of communication to the public if they violate reasonable and proportionate duties of care, which could now be adapted to their specific activity, basically resulting in an area-specific system of appropriate and proportionate duties of care. And could these duties of care also involve proactive duties? The answer is yes, they could, at least as long as there is specific notification and collaboration with the right holders, the latter delivering the necessary data. Now, we might be a little bit scared by this. Actually, I wouldn't be so scared by this. It's what's happening in Germany the last 10 years under the stay-down obligations. What happened then was that the right holders give a lot of titles, a lot of films, and these films have to stay down, and this hasn't actually existentially endangered the platforms. The question is rather where the interests of the user come in. Platforms' right holders never was a problem here. That was a point Martin Sendfeld mentioned this morning. Where's the user in that balance? And of course, the second set of duties would be notice, take down, and stay down. That would be pretty much the German concept of Störerhaftung, now filled in the dogmatic framework of secondary infringement, or whatever you want to call it. Otherwise, if the platform doesn't comply with all these duties, it commits an act of communication to the public, which of course raises the question of whether Article 14 e-commerce directive would apply. And here now, the proposal says clearly in the text that under these circumstances, the platform would be excluded from the hosting platform safe harbor, which of course now at least is transparent, but leaves us with Article 15 e-commerce directive, the prohibition of general obligations to monitor. And here the Bulgarian presidency seems to be of the opinion that this specific collaboration duties, even if they amount to proactive duties, aren't general obligations to monitor. I think that will give rise for a very interesting discussion. We had that discussion in Germany because we have to ask us of whether our very broad stay-down obligations can sum up to a general obligation to monitor, or whether they remain specific obligations, even if in the end of the day they cover almost all the material. And what about the users? Well, here is the good news. At least the proposal would guarantee that any licenses the platforms conclude with the right holders would have to cover the liability of the users. That is, they would indemnify the users. That is by no means self-evident. For example, we aren't certain whether the Google GEMA settlement in Germany really indemnifies the uploading users. We aren't certain. We don't know. It's under a non-disclosure agreement. So users would be indemnified by licenses. And then as regards the issues of freedom of expression, and in particular, specifically, the exceptions and limitations to copyright, such as parody, quotation, citation, pastiche, and the like, effective complaint and redress mechanisms shall be foreseen for users that safeguard use within the realm of these exceptions. And these complaint and redress mechanisms shall work on the basis of replies by the right holders in a timely manner, that is, according to one of the proposed recitals, within a reasonable period of time. Well, all that is very nice and reflects the requirements from UPC Telekabel. What actually raised my concern is that it says it's the right holder who replies. And in the text of that directive, it says further that the right holder within a reasonable period of time shall justify his request. Where does a platform come in? Even the platform coming in is a second best solution compared to judicial decisions, but it can't be the right holder who decides in the end of the day of whether that was used within an exception or not. So, might be a technical error, might be an error of redaction, but it's in the text of the proposal. That should be changed in every case. And also, of course, I'm not so sure whether all these complaint and redress mechanisms really work effectively for the users. Very often they will simply come too late. When I talk to people who are basically making a business out of making funny YouTube videos, and they say they live from the 1 out of 1,000 videos which goes viral. And when you break that wave and bring it back up on the net a week later, that will come too late for that kind of dynamic, and that's what they are hoping for. It's their once-in-a-lifetime chance. Either they go bust after trying it for a year, or they have one of those viral hits, and then they're successful people. So there is a real problem here with complaint and redress mechanisms. German government has reacted rather positively, and of course the alternative of coming back to the original proposal of the COM is still in the table. Even the jury committee in the parliament hasn't decided yet. They will decide beginning of April. So everything is still pretty much up in the air, but as Bernd said, it goes into that direction in the council. And actually, from my personal point of view, legally both the Bulgarian approach as well as the Commission's original approach could work. But the crucial question, of course, is whether they do make sense. And the first thing I don't like about these approaches is that meanwhile they are tampering a lot with the communication to the public, right? Which they shouldn't in the first place, but they do so in a very area-specific piecemeal way. They are addressing the specific field of audiovisual content and music, and they aren't addressing all the other contentious fields such as links, rebroadcasting, and the like. So actually, I don't think a piecemeal approach can work once I start tampering with Article 3 of the InfoSoc Directive. Plus, in all those open definitions, the real crucial element of communication in the framework of an own service for a receptive public is missing. Of course, the Commission says this is because we aren't redefining the Article 3 right anyway. It says, of course, all this is notwithstanding with regards to the case law of the court under Article 3, but still they are defining it in a specific area, and I don't think such piecemeal approach can work. Perhaps under these circumstances we should rather go back to zero and do nothing, leave it to the courts. That might indeed be a better approach. Secondly, what about the filtering duties? I'm not opposed to them on a principled basis. I think we need some of those filtering duties. The question is just to which extent. And my problem with it is that even for small and socially perfectly accepted uses, such as illustration, citation, description, these proactive filtering duties will, at the very least, cause a lot of transaction cost. And they might do so even in situations where such uses might be complementary to the interests of the right holders. That is very early, even in Landesposner's book, that citation, quotation, criticism, pastiches, collages might actually benefit the right holders to a certain extent, and that the very hard to make decisions whether it's still allowed or not cause a lot of transaction cost, and that this might argue in favor of permissibility of many of these uses. And so from my point of view, real content-based services in the future should need a license, which at least would reduce transaction cost, whereas those small uses should be exempted under a new remunerated exemption in copyright law. And that, rather, in the end of my presentation, brings me to the blue sky approach, because now I feel I have earned the blue sky approach, also having brought some hard information. And that is what my colleague Axel Metzger and I proposed in Germany. Actually, our more general approach would combine an overall definition of the communication to the public right with a remunerated exception for certain minor accepted social uses, such as, in particular, user-generated content. The right of communication to the public definition would combine an umbrella general clause, picking some of the elements of the ECJ's case law, with a non-conclusive list of positive and negative statutory case examples. That is an approach which pretty much links up with German unfair competition law, and in Europe with the Unfair Commercial Practices Directive. Umbrella general clause, non-conclusive list of statutory case examples, and it was also proposed by my colleague Ansgar Ohly in the framework of the Reconstructing Rights project, which Bernd Hugenholz organized in Amsterdam. And of course, as German poet Bertolt Brecht said, truth is concrete. So if you propose such a model, you should be able to say what your solutions would be. And indeed, at least we've tried to bring that into the political process. Of course, it's unrealistic to bring it through in the discussion of the directive, but at least as a future-orientated design, we would think that the right of communication to the public should be triggered by an act of communication, either reaching a new public or by specific technical means, although the only specific technical means would be first-time internet distribution, probably. No other decision on that, so perhaps that could be left out. But that would have to take place in the framework of an autonomous content-related service offered to a targeted content-receptive public, in particular by structuring the content. But all the hosts which don't structure the content as a content, but rather want to sell bags or shoes or whatever, would be out because they wouldn't use these works as a work. They would use them incidentally. And that would mean that broadcastings would be in, content platforms would be in, typical social networks would be out, as well as sales platforms, search engines would be out, hyperlinks would be out except for appropriating frame links, where technological solution for effective opt-out would be needed. Access providers, of course, would be out. And then this would be combined with certain elements to safeguard effective licensing of the rights for the prime services, the content services, such as YouTube, indeed. And it would, on a second stage, be combined with a new remunerated exception for certain non-commercial minor uses, in particular in social networks. That would have to cover the reproduction and the CTTP right, and it would cover certain minor non-commercial uses not conflicting with normal exploitation or prejudicing the legitimate interests of the right holders. And I think that the main advantage of this is that it could be technologically administered. The length of the musical pieces would have to be limited, quality could be limited, and then things like Facebook, where I just tell about my favorite song, would be out. Various YouTube, where I effectively look for the newest Paganini concerto to listen to it with my Sonos boxes, would be in. The remuneration would be collectively administered and would for the first time target the services as such, whereas our old traditional levies on the continent always targeted media and devices. So the system would become future-proof in that regard. Would this lead out of the dilemma? I do think so, which is for the following reasons. But is it realistic? No, it isn't realistic. For the moment being, we have to discuss that Bulgarian proposal. And in that regard, I think the main goal at the moment should be that at least nothing is done which does damage in the future. And in that regard, I think a proposal which is based upon a duty of care-based concept of infringement is not so bad in the first place. But then it would have to be more comprehensive. It would have to be a comprehensive approach to the CTTP right, putting a duty of care-based infringement concept in. It would then have to put the qualifications in from the court's case law. And if that can't be reached in the political process, Actually, I'm afraid we rather should do nothing and leave it to the courts. Although, of course, if that solution was taken, which is very compliant with market reality from my point of view, this probably could work. But that is indeed for the future, or perhaps for discussion. Thank you very much.